Hello, and welcome to this week's edition of Smart Counsel for Lunch. My name is attorney Sean Downing, and I'm an attorney here at the law firm of Samuel Sayward and Baylor, located in Dedham, Massachusetts. We focus our practice in the areas of estate planning, elder law, probate, and trust and estate administration. So today, I wanted to do a bit more of a deep dive into what that probate part is. I think a lot of people know that probate is something they want to avoid, but they don't necessarily understand the nuances of what it actually is. So quite simply, probate is just the process of retitling assets from the name of the deceased person into the name of their beneficiaries or heirs at law. So beneficiaries, if you have a will and you need beneficiaries who you want your stuff to go to, that's going to the beneficiaries. If you don't have a will or other estate plan, it goes to your heirs at law, and that's just what the Commonwealth of Massachusetts decides. Those are the people who get your stuff if you pass away without an estate plan. So just on that point, there's a common myth that a will help you avoid probate. That is not the case. A will just lets you change so it doesn't go to your heirs at law. It still has to go through probate. So what's the issue with probate? What's going on? In theory, all it is, you fill out some forms, you go to the court, you get appointed as a personal representative. It used to be called an executor. You get appointed, you retitle things, you're over, right? So there's a couple of hurdles that make it go a little slow and a little more expensive. First, those starting forms that you have to fill out are a bit more technical than people realize, and it often makes sense to get legal counsel just to help you through those opening steps at the very least, because it can be quite tricky what form to fill out, how to fill them out, which boxes to check. Because if you do it wrong, they'll just say, nope, this is wrong, and send it back to you, and you have to start all over again. So, in that case, it's expensive and a bit timely, even if you get counsel or not, for that opening stage. Now, after that, you have to wait a few months, and it really depends on where you live and what county you live in to actually get appointed and get the letters of authority. And that's the document you need in order actually to move things along, change things in different accounts, etc. Now, that's not the only thing that makes it slow down. There is a statutory reason that also slows things down. So a dead person's creditors have a whole year to file a claim against the estate. So let's say, you have a bunch of the dead person has a bunch of credit card debt, and then the credit card company has a whole year to file a claim to say that they deserve to get the money that wasn't paid to them when the deceased person was alive. So because of that, we can't close the estate until a whole year has passed. Now, what that means is the assets in the estate, the house, the big thing, are all kind of like locked up for a year. Now, there are exceptions. There's ways to, like say, sell that property within that year. But doing those exceptions, I want to make clear, are timely and expensive, and they're a bit of a hassle. So, it's possible, but it's a bit of a pain in the neck. So that's why at the end of the day, most people want to avoid probate just to make things move smoothly and to be less expensive, especially if they want to do anything, like access money right away, get things out to people. And often that's the case, especially if you're even family members who could really use that money, etc. So what do you do? Well, if someone in your life has passed away and they don't have a trust or some other estate plan that avoids probate, you're going to have to go through this process. Now, there's different types of probate depending on how many assets they have, whether they have property, etc. So it's often a good idea to speak to legal counsel. Now, if you're still alive and you're worried about your own future probate for your spouse, your children, your family, or your friends who are going to move that process along after you pass away, a good idea is to get a trust in place. The reason a trust avoids probate is because the trust becomes the owner of your property. So at no point does a deceased person own that property, because when you pass away, the trust still owns it. So it never has to be probated, because it never has to be retitled from a dead person to living people. So that's how trusts work. So it's a good idea to talk to an estate planning attorney if that's a concern, and you want to avoid this process for your kids and other family members. Yeah, so thank you for watching Smart Counsel for Lunch. Please like and subscribe to all our content and come stop by.